Thank you, Rana. Assistant Commissioner, as you know, my name is Sally Oslands and I'm appearing in this inquest for the Police Association. I just wanted to ask you some questions first of all about the disciplinary regime and the matters arising from the, I've been calling it the review report, but I think others have referred to it as the Galliot report.
Galliot report, yes.
Now, when my learned friend from Narja was asking you questions the other day about the Galliot report, you agreed with the proposition that trust and confidence is increased in any disciplinary system, or he was referring to the complaint system, when the system is well functioning. Do you remember giving that evidence?
Yes, I do.
And do you agree that that same principle applies when you're talking about internal disciplinary matters and dealing with a disciplinary system and complaints against police officers and their conduct?
As in relation to trust?
Trust, confidence, things of that nature.
Yes, I do.
And of course, not just from the members, but that obviously engenders trust in the community as well.
Yes, that's correct.
Now, you gave a bit of a rundown the other day on the general hearing process, that is the contested hearing process when an officer is charged, if you like, under Part 4 and the matter goes through a hearing process, and I can take you through it if you want, but do you recall giving the description about how a hearing officer is generally a commander, and then following the hearing the commander will make a finding and then a recommendation as to penalty?
Yeah, depending on if it's within their scope of giving the penalty as a prescribed member, they can. If it's not within their scope or they believe it's outside of their scope, they can make a recommendation to the delegate.
Yes, that's the evidence that I'm referring to. And the delegation that you're referring to, is that formal delegations given by way of a statutory instrument?
Yes, it is.
And it's the case, isn't it, the Commissioner of Police has delegated all functions and powers under the Act, that is the Police Administration Act, to you as an Assistant Commissioner of Police?
To Assistant Commissioners, yes, as well as there's a schedule attached where he has delegated powers for other things within the Act.
Yes, and that delegation also applies or delegates all functions and powers under the Act to Deputy Commissioners, does it not?
Yes, that's correct.
Yes. So just going back to the hearing officers, if they believe that the sanction to be applied is within their delegation, they'll deal with it?
Only if they're acting as a hearing officer, they're a hearing officer as a prescribed member. So they're acting under the prescribed member's powers and levels of what they can do as per the police regulations. So they're acting as the prescribed member, not as the commissioner.
Yes. So just to clarify, I think it's, and I'm not trying to test your memory, I think it's Regulation 18 of the Police Administration Regulations sets out the limit of sanctions that each rank can impose.
Yes, that's correct.
So, and it goes up in seriousness of penalty.
Yes, that's correct.
Yes. So, if a hearing officer thinks that a sanction more than what they're entitled under their own rank to impose, then an officer of a higher rank will impose a penalty.
They can refer it to a higher prescribed member, or, sorry, at the end of the hearing, they can refer it to the commissioner or his delegate.
Yes, and that person, delegate or commissioner, makes a determination based on their powers as set out in the regulations.
Yep.
Yep. So,
well, no, not as regulations. As a commissioner, the commissioner has all the powers.
If referred to you, obviously.
Yeah, because the commissioner is not a prescribed member, so Regulation 18 does not come into effect.
Yes. So, when the hearing officer refers a matter, do they, generally speaking, refer it to a member immediately above them, or is it the practice that all matters go to you, for example, with all the powers and functions of the commissioner?
No, as a result of a hearing, the hearing officer, if it's out of their powers, refers it and does a report to the commissioner of the police or his delegate.
Right. Do you see, broadly speaking, an issue with determinations as to sanctions and penalties being imposed by an officer who's not seen and heard all of the evidence in the course of a hearing?
The person who's imposing the determination is not determining whether the evidence was proven or not proven. That is the hearing officer. The hearing officer is making a recommendation. They're either making their own determination or a recommendation re penalty as to the seriousness of the offence, which also takes into account a wide range of other things, including previous disciplinary history and all those type of things.
Sure, like a sentencing hearing almost.
Yes, pretty well.
Yeah. So the officer who, the delegate, if you like, who's ultimately making the penalty in relation to sanctions is relying only on the report that they've been given from the hearing officer, in addition to those matters that you've just mentioned?
You take the opinion or the recommendation of the report, but you also do look through the file to ensure that what's in that report and the findings that were come to, that the evidence was there for that hearing officer to come to that finding. But ultimately, the recommendation is, not the recommendation, the determination is made on the penalty, not the actual, whether they're proven or not proven, because they've already been proven.
Okay, and are directions ever given to hearing officers about the way they're to conduct hearings or matters they're to take into account?
Sorry?
Are hearing officers, the prescribed officers, are they ever given directions by more senior officers as to how they're to direct the hearings?
No.
Where a hearing officer makes a recommendation, it's the case, isn't it, and I think you've just mentioned this, that the hearing officer will also make a recommendation as to penalty.
Yes, that's correct.
Yeah. And is it the case that higher ranking officers and delegates regularly don't accept those recommendations?
Yes, on occasion.
And where a higher ranking officer who has delegations of the commissioner makes a determination as to penalty, what are the avenues of appeal for the officer?
After the determination is made by the...
After the penalty, yes,
Yes,
sorry.
no, they have ability to make application for an appeal to be heard before the police appeals board.
Is the effect of, rather than the hearing officer imposing a sanction under the powers attributed to them by the regulations, rather than them dealing with it, when they refer it to a higher officer, that effectively removes the right to seek a review internally of that decision, doesn't it?
Yes, that's correct.
So the power or the right to seek a review is removed, and the only avenue for officers is to lodge an appeal notice for the disciplinary appeal board.
Yes, that's correct.
Are you aware how long it generally takes for an appeal to be heard?
At this point in time, it can take anywhere from 6 months to 2 years.
So it's the case that there are officers who have had a sanction imposed who can't have their matter finally determined for up to 2 years.
Yes, depending on the availability of the police appeals board.
And how is the police appeals board constituted and formed?
So the police appeals board, the chair of the police appeals board is a person that's appointed by the minister. They have to meet certain thresholds within the Act. They have to be a lawyer, they have to have 5 years experience as other criteria, and then they are selected or approved. It goes through the minister and gets approved over through cabinet.
So that's the chair. Who else sits on the appeal board?
It's on the appeals board. There's a representative on behalf of Northchurch Police Force and also a representative on behalf of Northchurch Police Station.
And who does the secretariat services for the appeal board?
We have a register, an appeals registrar, and that sits within the HR and wellbeing area of the Nigel Police Fire and Emergency Services.
Sure. Do you agree that 2 years is an extraordinary amount of time to have a sanction determined,
Yes, I do agree.
and would cause members significant stress in terms of waiting for their matters to be determined?
Yes, I do agree.
And while they're in that period, not in every case, but in many cases, that has the effect of either prohibiting or inhibiting transfer, promotion, things of that nature.
Yes, that's correct.
And that also goes with members who are being either dismissed or retired, does it not? In terms of notices being issued by delegates of the Commissioner that their only recourse is to appeal to the appeal board.
Yes, dismissed when it comes to retired, when they lodge an appeal through Part 5 for retirement, as in medical retirement or other retirement, they're actually not separated from the agency.
They're not.
No.
But they too are at the hands, if you like, of the availability of the Police Disciplinary Appeal Board, not the Part 5 matters, the disciplinary matters.
Yeah, it's the Police Appeals Board. It's not a disciplinary appeals board. They undertake appeals for a number of things: discipline, promotion appeal, retirement, or inability appeals.
Sure. Do you think that model, that appeal model, which relies on the availability, as you've described, of members to sit, that's something that requires, a review and significant amendment going forward?
Yes, I do, which is basically a recommendation of Commander Galliot in his report to try and move away from that appeal board process.
Sure. Just since you raised the Galliot review, in relation to dismissals, you might have heard the Deputy Commissioner's evidence the other day, and I certainly acknowledge that the matters are still being consulted about, but the Galliot report recommends a dismissal system whereby a member can be effectively terminated by an Assistant Commissioner within a 7-day period and not have any entitlement to resume their job, even if on appeal it's found to be harsh, unjust or unreasonable. What are your thoughts on that?
I believe there needs to be an avenue where you do have the ability to separate a member from the police force, which are technically loss of confidence provisions. It might not necessarily be just in relation to discipline, but a number of performance issues where they're not performing as a member of the police force, but how that would actually work is yet to be really fully examined through stakeholder engagement as to the ability to do that or the feasibility to do that.
I guess the biggest concern for members would be certainly not an issue with ensuring that police officers are operating at a high standard, but even if determinations to dismiss them are found to be unreasonable, that they still have no entitlement to return to their jobs. Well,
if they're performing at a high standard, I can't see why they'd even be activated.
So I'm saying, you don't see that there's a risk there that members who've successfully appealed a decision to dismiss shouldn't be allowed to go back to work?
To be honest, I haven't really thought about it too much because, like I said, it's a recommendation of Commander Galliot. It's something that we don't currently have. A fair process, you need to look at procedural fairness and avenues of whether the procedural fairness is in place. So during the process, we would have to determine that we do have the assured levels of procedural fairness for members.
Sure. Just moving on a little bit to perhaps how you foresee the new system, and I fully appreciating that it's yet to be fully nutted out, but I think it was reported by Commander Galliot in his report, and I should have noted, Your Honour, that's BP 16 to the affidavit of Assistant Commissioner Porter in February. And he reported that it was agreed by all parties that he consulted with that the current complaint and discipline systems do not provide an educative or supportive framework that reflects the realities of the NT police environment. Do you agree with that statement?
Yes, I agree, and I gave evidence the other day that I said we need to go to the more modern managerial model to develop our members.
Sure, and that's sort of where I'm going with this line of questioning, and I think Deputy Commissioner Smallpage agreed the other day too that it's desirable to go to a more managerial or a management type model. Why is it that that can't be affected right now? Not the whole kit and caboodle, but if the philosophy has changed towards a more managerial focused approach, why are we still seeing significant numbers of serious breaches of discipline being progressed?
Because under the managerial model, it goes up to, if you, according to Commander Galliot, goes up to demotion. And the only way you can do demotion currently is through Part 4 action.
Perhaps going back a step, at the moment, and we've heard a lot of evidence about remedial advice, which I think you'll agree, remedial advice is not a formal term that appears anywhere in the Police Administration Act.
Yes, that's correct.
And it's simply a reference to managerial guidance being provided to members to improve their behaviour. So currently we have the option of providing remedial advice as a management tool. Then separately there's disciplinary action that can be taken under Section 14 capital C of the Police Administration Act.
Well, it's still managerial guidance. It doesn't fall under the formal discipline division of the Police Administration.
Quite right. It's not part of Part 4, and there's no time limit imposed on providing a counsel or caution or something of that nature pursuant to Section 14C.
Yeah, that's correct. There is no time limit that applies.
And then in the third and perhaps most serious tier, you've got serious breaches of discipline, and of course Section 79 requires a prescribed member to form a view that it is a serious breach of discipline before commencing action under that section. You agree with that?
Yes, that's correct.
So we already have the 3 tiers in a disciplinary model which allows for managerial guidance, something a bit more formal under Section 14C, and the serious breaches of discipline.
Yes, we do, but only to a certain level.
Well, I'm sorry, what do you mean by a certain level?
Of course, when you look at 14C, it is managerial guidance for matters, and it is written in the Act, matters of a very minor nature, So whereas the managerial model that is being proposed by Commander Galliot is that you'll be doing the managerial intervention for matters that are higher than minor misconduct.
Yes, so the Part 4 deals with obviously serious breaches. Sorry, I'm just pulling out 14C, I don't want to mislead you. Yes, so under the new proposed model, I don't know how it's going to be described, but the equivalent of a prescribed member would have to make a determination whether conduct was something that could be addressed through managerial guidance or whether it's a breach of discipline. That's under the proposed new model.
Yes, under the proposed model, the breach of discipline is, on my understanding, is that it is of those matters of such serious nature that there is a requirement to separate that person from the police force.
And that's the view, that you take disciplinary action where there's a view that they might be separated.
That's such serious nature.
So isn't that sort of akin to what we have now? Either of those models requires a prescribed member to make a determination or to exercise their discretion as to whether they're going to manage the officer or whether they're going to institute disciplinary proceedings.
Yes, that is akin now, but it's on assessment of the level of the conduct that has been committed. And like I said, it is for the minor natures, which is a breach of, so for instance, you haven't followed a policy for some reason, you have, when interacting with a member of the public, you have been rude to that member of the public, you could take action under Section 14C to provide that counselling or that guidance to that member under Section 14C. Anything above that under the current process is you have to enact Part 4.
And under the new model, guidance would be given or disciplinary action would be taken.
That's correct.
So the Galliot review...
that lower level will have a much broader
It'll be broader, yes, you're right.
than simply limited to matters of a minor nature.
You'd agree, though, that on either model, it still requires a more senior member to properly exercise discretions and have an understanding of breaches that might be more than minor breaches of discipline, or which are simply conduct matters that are addressed through a managerial guidance process.
Well, it is anticipated, once it is fully established how it will work, that there will be categories put within a general order or similar that will describe the types of behaviours that would fit in with that model.
Right, so you do anticipate that there'll be a general order or a standard operating procedure to guide officers in the exercise of those discretions?
Yes, it definitely will be.
Because we've heard over the last few days evidence of, well, certainly Deputy Commissioner Smallpage gave evidence to the effect that general orders weren't guidelines, they were orders, but then also acknowledged where sometimes general orders might not be followed, and it's up to prescribed officers to decide whether or not action will be taken against that officer.
Yeah, I remember hearing that.
Yeah, and he agreed that that could lead to a perception of double standards or inconsistency in the way disciplinary proceedings are applied. Do you agree with that?
Yes, I agree. Is my understanding of that, and there are times when members will not follow a general order, but it is the circumstances they're faced with at the time that is pretty well impracticable for them to follow, or their actions was reasonable circumstances. But it's all going to be dependent on the assessment of every individual matter.
And I think that's what I'm getting at. How do prescribed officers and higher ranking officers than senior sergeants, how do they know how to assess those matters, and how do members know where the discretion is going to be exercised?
Yep. So at the moment, so for example, you have excessive use of force, right? The allegation of excessive use of force. During the incident, they have not complied with how they're supposed to put handcuffs on properly, as per their training and as per the use of force general order, as in the behaviour of the person at the time was such that they were unable to fulfil or undertake the action that is required to handcuff the person in line with their training and their instructions.
Okay. What about something a bit more intangible, like we've heard evidence in the course of this inquest about...
Sorry, I don't really understand that example. So you've got an example where you've accepted a reasonable explanation. So where does that fit?
That would fit then, you'd be given the remedial advice. I'm not quite sure how it's going to fit in with this new model, Your Honour. I really do not at this point in time. But under the current system, that fits in as remedial advice, as in, this is your general order, this is how you're supposed to do it. I understand that you couldn't in the circumstances, but you need to be mindful that this is the proper way.
And there's no guideline as to how that assessment will be made by prescribed officers.
No, it's all on assessment on the circumstances that they review.
Oh, the only other thing I wanted to ask about that came out of the Galliot report in relation to disciplinary proceedings is that one of the comments made was that whilst disciplinary sanctions are often imposed with a view to providing general deterrence and setting a standard of police behaviour, he commented that disciplinary decisions are not published. Is that something that's being contemplated for the future? Obviously de-identified or whatever, but is that something that's being considered?
It is being considered, and it has been done. It has been undertaken before, as in we've done the identified case studies. However, because we're such a small jurisdiction, it doesn't seem to take long for people to know who the persons or the members were, who are the subject officers. So we are currently examining, in line with other jurisdictions, as we're part of the Professional Standards National Forum, to get case studies relevant from other jurisdictions that we use as examples.
Okay, because you would agree that that's the sort of thing that might allay the perception of double standards or an inconsistency in the way the processes are applied.
Yes, we agree.
And the other thing that I wanted to, sorry, I said that was the last thing, but I've just got one more note. Commander Galliot noted that part of the delay in progressing matters is that he said simple matters are being referred to the Deputy Commissioner for consideration. Why is that? Why are simple matters being elevated?
I can't say where that comment or where he got those comments from. I'm not aware of any simple matters that have been referred to the Deputy Commissioner, because the Deputy Commissioner acts as delegate to the Commissioner and only the high level matters go there.
I think we've covered it, but it's obviously, it has been acknowledged that these disciplinary processes that we have now, and also it's not yet really worked out how it's going to work in future, but it's been acknowledged that the disciplinary process itself and other internal processes can actually re-traumatise officers who've already been exposed to traumatic situations. Do you remember reading that in the report?
Yes, which is why, as part of his recommendations, is about the integration of health services and health and wellbeing, and ensuring that there's support mechanisms in place for members.
Yeah. Do you have any idea what they might look like?
No, I do not at this point in time.
Just in relation to Part 5 processes, obviously, as you were giving evidence about yesterday, officers are retired for incapacity from time, or sought to be retired for incapacity from time to time. Does the Northern Territory Police Force keep any data or stats about how many of those inability retirements are on mental health grounds?
They would do, but I don't have those stats.
Do you know if those stats are used for any purpose?
I can't tell you, I don't know.
Do you know if support and welfare services are available to members who are being retired for on inability grounds?
Yes, they are providing those services, and we still continue providing those services till at least 6 months after.
6 months afterwards. I was going to ask you about that. I think there was some evidence.
I'm really sorry to ask this, but I'm just not quite sure how this is relevant to my inquest.
Well, Your Honour, I wasn't going to take that any further, but it goes to the whole review of the disciplinary process and the welfare of members.
It might, but it's delving into detail which is not arising in this.
I won't take that matter any further, Your Honour. I just quickly wanted to ask you about the transfer and promotion process that we've heard some evidence about, and the I think there was some evidence from Deputy.
I suspect this is also not maybe it arises in this inquest, if you can.
Well, we're talking about robust processes and the ability of particularly sergeants and senior sergeants to do their job has been raised in the inquest. And as I understand it, Assistant Commissioner Porter is responsible for the promotion and transfer of members and also oversights the college, which is responsible for training members.
Sure. So we're talking about, you're identifying how sergeants or people are promoted to those positions?
Yes, and there is a general order which I did want to introduce because I don't think it's on the brief, and it is the general order relating to promotions and transfers. I don't need to go to it, but I would ask the council assisting give consideration to adding it to the brief. Just briefly, Assistant Commissioner, it's the case, isn't it, that under that general order for promotions and transfers, it's the Deputy Commissioner who's responsible for making determinations on transfers and promotions?
No, not all the way, not always.
Oh, do you want me to take you to the general order?
Yeah, so is you're not identifying ranks here, but of course we also have transfer promotions for for commissioned officers, and that goes to the commissioner.
Sorry, I was talking about non-commissioned officers, and the document does say that. I did send it through the other day, and perhaps that could be Sorry, Your Honour, I didn't anticipate spending too much time on this. It was basically just to establish the basis on which non-commissioned officers may obtain transfer and promotion, and if perhaps specifically from General Order 54 of that document. So sorry, specifically at 54, the Deputy Commissioner, People, Culture and Capability, has responsibility for making determinations on the transfer of members, taking into account recommendations, and separately making a determination on promotion of members, taking into account recommendations of a panel. And you agree that there is a panel for promotions and a panel for transfers?
Yes, that's correct.
And I think the general orders make provision for you as the Assistant Commissioner to chair those meetings and to be responsible for the recommendation made to the Deputy Commissioner.
Can you tell me the section is? So it doesn't make me responsible as chair, it makes me responsible for determining panels.
Sorry, can you just say that again? The general order which says...
It provides responsibility to me to determine panels.
Yes, I
the
can.
makeup of a panel.
General Order 65. Yes. And there's a discretion, you have a discretion to choose the other panel members and obviously a right of veto in overriding that.
Chairperson does. The Assistant Commissioner can appoint a chairperson, and then the chairperson has a discretion to choose the other panel members.
Yes, and the Assistant Commissioner may override that decision. Right. So is that the way it ordinarily works? That you appoint a chairperson and there's a panel that decides all of the things that need to be considered and then a recommendation is made to the Deputy Commissioner?
Yes, so with sergeant promotions, I appoint a commander as the chair of the panel, with recommendations to the chair as to the availability of people who are available to be part of their panel, and to take into account also, to have a gender ratio on the panel, and also if there's any Aboriginal applicants, that there needs to be consideration taken to include someone on the panel who has Aboriginal background or ATSI background. So that occurs with sergeants. With senior sergeants, a decision was made, including me as part of the decision making, that the senior sergeant panel will be chaired primarily by Deputy Commissioner, myself, and then there's Executive Director of CREC, that's Community Resilience Engagement Command, Your Honour, and the Director of Human Resources and Wellbeing, and to keep the same panel just for consistency of decision making.
Do you see an issue with the Deputy Commissioner sitting on a panel that makes recommendations to him for final determination?
No, he has not been signing off on those recommendations. It either goes to the other Deputy Commissioner or the Commissioner of Police. And he is just the chair. There are 4 panel members and decisions are made on selection through the unanimous decision of the panel.
I don't mean to appear critical, but that's not in accordance with what the General Order says, is it?
No, the General Order says at a minimum the structure, so that indicates to us, and which we have been using, that it can be above the rank of Commander.
Well, it says Commander or above.
Yes.
Yeah. So my question though is, in terms of making a recommendation to someone to make a final decision when they're sitting on the panel, is that something that causes concern?
Yeah, but he's not signing off on the panel decision. He's the chair, so he's making a recommendation to another senior officer, as in, and it's generally the Commissioner.
The only other thing I wanted to ask you about the sergeants is just a general question arising from some of the evidence we've heard throughout the inquest, that the sergeants have a huge and varied workload, and from the various discussions, it seems like a lot of their work is administrative, and we've heard that they are responsible for managing rosters and managing resources and all those sorts of things, which some sergeants have given evidence has caused them to be effectively desk bound rather than being out on the road with their troops. Do you see that as being something that can be adequately addressed through the training programs that are being introduced?
I'm not quite sure, and I'm not quite sure which sergeants you're talking about, because sergeants have specific duties. So, for example, a sergeant in charge of patrol group or front line for that shift, they don't have responsibility for rosters. They have actually a administrative sergeant in the station who has responsibility for rosters. So you would need to provide me further clarity as to what the actual burden is for each specific position.
All right, maybe I'll leave that. Just 2 other things very briefly. Alcohol and drug testing and the development of a policy in relation to that has been discussed in the inquest. And you'd agree, there has been collaboration over a number of times. Do you agree that an appropriate policy is something that needs a welfare response as opposed to a punitive response?
No, I do not agree. I agree that it's a welfare response if people are having issues in relation to prescription drugs or similar. But if someone is taking drugs that are illicit and committing offences, it is not a welfare issue. It is they're breaking the law.
Okay. Now, feedback as far as my client's concerned has been provided in relation to the draft, and I think there was some evidence briefly the other day about the importance of ensuring that a policy appropriately takes into account the situation of members at remote stations.
Yes, that's correct.
And do you have any thoughts on how a policy which prohibits officers from either consuming alcohol or, for example, taking prescription medication can be dealt with in circumstances where they have to be reasonably available the whole time when they're in the community?
Yes, we, excuse me, Your Honour, we have not completely worked that one out yet. We are still in discussions and getting other information from the other jurisdictions who also have police officers in remote locations. At this point in time, we have not fully determined exactly how it will work, but as I previously stated in my evidence, the draft policy or general order, as it will be a general order, will be going back to the North Territory Police Association for further feedback once we have a position on that.
Okay. They're all my questions. Thank you.
Other questions?
Your Honour, I'll be brief.
Yes, sir.
Assistant Commissioner, as you know, my name's Luke Officer and I'm here for Constable Rob. There's just three topics I want to cover with you.
Of course.
The first, just one issue arising from the accidents on the 9th of November 2019. The second is body-worn video, and the last topic is the rider matter, although not in any direct detail. Unlike Commissioner Smallpage, you were in fact in the Northern Territory Police at the time of the incident. There was this inquest when...
Yes, I was commander at the college.
One of the matters that was is of significant concern to my client at the time and certainly now was the rapid speed at which he was identified as the police officer who pulled the trigger on the fatal shooting. Are you aware of that?
I'm aware that that's been raised, yes.
Identified within the media very quickly. Did you, in your capacity in Northern Territory Police, or are you aware whether inquiries was made as to how it occurred so quickly?
No, I have had no involvement or unaware. I had no real involvement with the matters pertaining to Yuendamu until I come back from long service leave in mid-June 2020.
I'll move on. In terms of the body-worn video, generally speaking, your evidence was that 600 cameras were rolled out at about September 2016. Can you just take up Exhibit 24 quickly? Exhibit 24 is the table that was handed out.
Oh, sorry.
You did that?
Just said Exhibit 24, I wasn't quite sure what it was.
Now you'll see in the years 2017 to 2019 and 20, quite a, what we've said in the evidence is quite a high number of, and I'm just looking at the non-activation line, body-worn issue, non-activated front line. Quite high numbers there.
Yes.
Did the organisation, and as you're sitting there today, do you have any evidence or appreciation of why the numbers were so high in those years, in terms of explanations from members who didn't activate, or is that just the raw data?
No, that's just the raw data. I haven't really delved into the actual reason why back then,
Sure.
other than it was still a fairly new process for police officers. It's something that police officers never had before in the Northern Territory.
Right, so they were getting accustomed to it and something they had to take the time to get used to.
That was my understanding, but I don't have the definitive answer, no.
Yes, right. But what we do know, I think you said your evidence earlier this week, that at least in the lead up to the 9th of November 2019, Constable Rolfe demonstrated an increased and better use of body-worn video despite the prior matters where he had it.
Yes, and that was highlighted by Superintendent Vickery when she undertook audits or did tests.
Yes.
audits for a better term.
And of course, we know that on the 9th of November 2019, Constable Rolfe did indeed have his body worn video activated.
That is correct.
Just in terms of the rider matter, just the third and last topic, you've given some evidence about what seems to be, in my words, tell me if they're wrong, a discretion used at prime and command level as to whether or not to refer a matter to the DPP.
Yes.
And you take into account, for example, the paucity of evidence.
Sorry.
You take into account in those decisions the paucity of evidence available to you,
Yes.
the reliability of the evidence, if there's inconsistencies between witnesses.
Yes, that's correct.
And you're aware, aren't you, in the decision of Judge Borchers, one of the criticisms at which he drew a conclusion, or in his view, a finding that Constable Rolfe had lied, was that he couldn't accept that Constable Rolfe had been punched in the hallway or that he had been scratched on the eye, as Constable Rolfe deposed to both in his evidence and in his statutory declaration.
Yes, that's correct.
And you, in your third statement, at paragraph 47, reference specifically one of the matters you've taken into account is the fact that Constable First Class Chatterton gave a statement, 28th of March 2018 on the brief, that's 3144, that he had seen immediately after the incident involving Malcolm Ryder that Constable Rolfe had a mark on his head, and in your words here, that supported Constable Rolfe's account that he was scratched or clawed in the interaction with Mr Ryder and received a mark in these circumstances.
Yes, that's correct.
That's quite significant evidence, isn't it?
It is, yes.
And why is that significant in your view?
Because it's current, it's contemporary, it's at the scene, and immediate after the incident.
And it corroborates Constable Rolfe's version.
It does, yes.
Are you aware that Constable Chatterton was not called at the trial of Malcolm Ryder?
Yes, I am aware.
Do you know why that decision was made?
No, I do not.
Did you speak to the prosecutor who made that decision?
No, I did not.
That's a pretty significant matter that was absent the evidence before the judge.
Yes, I consider it was.
Your Honour, just before the counsel assisting resumes her questions, Mr Officer and I have reached a truce negotiated by Mr Freckleton, Dr Freckleton I should say, and I'll withdraw the question.
Thank you. Your Honour, Assistant Commissioner, do you know whether or not Officer Chatterton wasn't called or was a forensic decision made to tender his statement at the hearing?
I do not know.
Did you make any inquiry as to
No, I
whether
did
that
not,
was done?
because I was not part of that investigation.
So in response to Mr Officer's question about whether that was a pretty significant oversight, you can't say, can you?
No, I can't definitively.
What did you Well, in response to Mr Officer's question that was a pretty significant issue, you can't say, can you, without knowing that?
No, without knowing it, but his evidence is pretty critical, as in he provided direct evidence of his observations at the time.
And do you know whether or not his statement with those observations was tendered and available to Judge
No, I
Borchers?
do not.
So you don't know whether or not the prosecution made a forensic decision not to call him?
No, I do not.
I'm going to stick with this questioning about the Malcolm Ryder incident. You were asked some questions by Mr O'Brien about the decision of police not to refer the investigation of perjury to the DPP. I'm not suggesting to you in these questions, Assistant Commissioner, that Constable Rolfe or others should have been charged with perjury. I'm not suggesting to you that they would have been convicted if they had been charged. The questions I have for you are in relation to the issue of independent oversight
Yes.
that Mr O'Brien was asking you about. Judge Borchers, in making his decision on the 9th of May 2019, made findings that 3 of your officers had given evidence at times that were not supported by the evidence available, the objective evidence.
Yes,
Do you recall that?
I agree that is.
There were damning findings made by Judge Borchers, weren't there, in relation to the credibility of 3 officers, particularly Constable Rolfe?
He made those comments in his summation, yes.
It's very significant, isn't it, given your experience in the Northern Territory, for a judge of a court in the Northern Territory to make findings adverse to the credibility of police officers?
Yes.
They should, in terms of oversight of your officers, be given significant weight, shouldn't they? The findings of a judicial officer.
It needs to be looked at very carefully, yes.
The evidence available to Judge Borchers included the following, didn't it? First, body-worn video from some, but not all of the officers involved.
Body-worn video from one officer.
Contrast between the evidence of the officers involved and the available body-worn video.
Yes, that's correct.
Contrast between the evidence of the officers involved and some mobile phone footage that had been taken by a civilian.
Yes, the mobile phone footage was footage outside
Yes.
the residence.
But in terms of assessing the credibility of the witnesses, civilians and your officers, he had available to him, didn't he, a contrast between that footage and the evidence of the officers.
He had it available to him, yes.
And that could be relevant, couldn't it, in terms of assessing the credibility of the officers?
Yes,
overall?
that's correct. That's correct.
And he also had the advantage, didn't he, of assessing witnesses giving evidence on oath.
Yes, he did.
You're aware, aren't you, that in courts around Australia, people can be convicted of very serious offences where there is oath on oath and a requirement of a judicial officer to
Yes,
assess
I'm
credibility.
aware.
And the juries perform that job as well, don't they, in terms of assessing the oath on oath credibility?
Yes.
And did you take into account, in placing weight on the findings of Judge Borchers, that he had an advantage that was not then available to police investigators of assessing oath on oath the witnesses who happened to be Aboriginal and the police officers?
Did I take into account?
Yes. Well, I would draw that. Do you accept that police investigators should take into account the significant advantage that the
Yes.
judge has?
No, I agree.
The judge was entitled to take into account the evidence he heard on oath from police officers and the way in which it contrasted with the phone footage outside the house in terms of assessing their credibility generally, wasn't it?
Yes, he can take that into account.
And did you take that into account when you were looking at this evidence subsequently?
Yes, I did.
Judge Borchers found that police officer Boney demonstrated ill will, irritation and incredulity that the occupants didn't have a key to the house. He said she was plainly rude and abrupt to Rebecca Hayes and Malcolm Ryder, and they were neither very hostile, which Boney alleged, or aggressive, as Constable Rolfe alleged. That was relevant, wasn't it, in terms of an assessment of credibility?
That was his assessment.
Did you make the same assessment?
No, I did not.
Did you not think that they were rude or aggressive to the occupants?
No, I did not. And when you take into account the footage from Ms. Hayes, they were referring to that when asked about did he have keys to the house, Mr. Ryder showed his pockets and said didn't have keys. There is no capture of the conversation before that. And Mr. Ryder at that time, he didn't just say, sorry, I don't have keys. He came out, no, I don't have. He was very aggressive. He was pretty aggressive when he said he did not have keys and pulled out his pockets. So there had to be some conversation prior to that footage, which is not captured.
Why was it not captured?
I do not know.
Did you think that that Judge Borchers was entitled to take into account the fact that it wasn't captured in assessing the credibility of police officers who had an obligation to record on body-worn video anything of significance?
Plus, also, when I look at that footage, the police officers said that they were sworn at by Mr. Ryder. I've looked at the footage and I've looked at the transcript where Mr. Ryder has, I think, called Constable Rolfe a fucking dickhead and a fucking idiot, and also said rocks should be thrown at them.
Is that not captured on the body-worn video?
Yes, it is. On the phone. So that's captured on the phone.
Sorry, who do you think said that?
Mr. Ryder said that, and Mrs. Hayes said that as well.
Excuse me. Well, that's a matter that we'll check ourselves, Assistant Commissioner. This is what Judge Borchers goes on to say. Prior to this, their interactions, and he's talking about Constable Boney, Rolfe and Zendelli, had been less than civil to Miss Hayes and Mr. Ryder. In fact, each had been rude towards Miss Hayes and Miss Ryder. Assistant Commissioner, I've watched that footage myself. It's an assessment that I'll invite the court to make that they were rude. What did you think when you
Your Honour,
watched
I
it?
object to the council assistant giving evidence from the bar table.
It's not evidence, I'm
Well,
asking.
you're saying you've watched it yourself, and this is what you say.
All right. In fairness to you, Assistant Commissioner, I anticipate submitting to Her Honour that an objective assessment of that footage shows officers being rude to Aboriginal civilians who are being asked questions. What is your assessment of that footage?
My assessment is Constable Zendelli was rude. I was unable to make that assessment re Constable Bonnie and Constable Rolfe.
Judge Borchers says, I cannot accept the evidence of either Constable Rolfe or Constable Zendelli when they say they saw punches thrown by Mr. Ryder.
Just before you go there, sorry to interrupt. Because I haven't seen the footage, I don't know what it's in it. They were Zendelli, Bonnie and Rolfe together when you say Zendelli was being rude?
No, Your Honour. Zendelli in the initial interaction was sort of away from them, but Zendelli is, when they went into the house, Zendelli pushed Malcolm Ryder outside the house, and she was not very civil when she was telling him to get out of the house.
So there could have been a reaction to her behaviour,
There could have been, yes.
which might account for anything else that is done, like turning out pockets.
No, the pockets was before that, Your Honour.
I don't know the order.
Has Officer Zendelli been given any remedial advice or any other sanction in relation to being rude and
No, not
pushing an
in-
Aboriginal civilian out of the way?
Not in relation to that matter.
Why not?
Because the investigation was completed and we just did not go back and provide that advice.
Should you have done?
Yes,
Judge Borchers said, I cannot accept the evidence of either Constable Rolfe or Constable Zendelli when they say they saw punches thrown by Mr. Ryder. Neither Constable Lorraine nor Duranis saw any punches thrown, and both were closer to Ryder than Zendelli. A body-worn video shows no punches being thrown. Did you agree with that assessment?
yes, I agree.
It's on that basis, or part of that, that he says Constable Rolfe and Zendelli's evidence is wrong and is a pure fabrication. That is an extremely serious finding for a judge to make. Do you agree?
He made other assessments to come to his finding.
He says this, I'll read the whole paragraph. I cannot accept the evidence of either Constable Rolfe or Constable Zendelli when they say they saw punches thrown by Mr. Ryder. Neither Constable Lorraine nor Duranis saw any punches thrown, and they were both closer to Ryder than Zendelli. A body-worn video shows no punches being thrown. Constable Rolfe and Zendelli's evidence is wrong and is pure fabrication. That's a very significant finding from a judicial officer in relation to the punches thrown.
That was his finding, yes.
In terms of assessing the credibility of your officers versus the civilian witnesses who happen to be Aboriginal, can I ask you to consider the evidence of the credibility of Mr. Ryder? He was reviewed by Dr. Nick Tylis at the Alice Springs Hospital shortly after 3:15 p.m. on the 11th of January 2018. Were you aware of that?
No, I wasn't.
He gives an account to the doctor consistent with his account in the hearing, complains of being forcibly arrested, that even though he was compliant. He says his face was, Malcolm said he complied, but the police officer forcibly hit his right face against the floor and punched him to his left face. That was the same account that Mr. Ryder gave to Constable Campagnaro as she was then when he was interviewed under caution. It was the same account that he gave in court under oath, and he gave evidence in circumstances where the judge had an opportunity to assess his credibility. Do you think that's a matter of significance when you're taking into account the comments made by a judge?
It is no doubt that he had his face hit on the floor and he was punched, and that is the evidence of Constable Rolfe. There is no doubt that that did not occur.
I think you can probably hear Mr. Coleridge there. Constable Rolfe's account was that he fell to the floor and hit his head.
No, Constable Rolfe's account is he actually tackled him to the floor.
You made, you accept the comments of Judge Borchers that Constable Rolfe and Constable Zendelli were not telling the truth when they say they saw punches thrown by Mr. Ryder?
No, I don't accept that as his summation. I don't know what was in the mind of the members. All I know is it happened within mere seconds. You have two people coming into the room aggressively, and they say in their evidence, if Mr. Ryder says in his evidence that he did come in aggressively, the officers have reacted instantly. I don't know if you've ever been in a situation like that, but you do not, when arms are going everywhere, you don't recollect completely everything. And then in Constable Rolfe's evidence, he then indicated when he did get punched in the head, it wasn't actually in that bedroom, it was down the hall when he was pursuing Mr. Ryder.
And you made an assessment that he was just mistaken when he said earlier that Mr. Ryder had thrown a punch at him, is that right?
No, I didn't say that, but I said in his mind he thought, I can't say. And it was the assessment of the judge of his time, and I'm not disputing the judge's assessment of that at that time.
Was Judge Borchers entitled, I would draw that, Judge Borchers was entitled to take into account, wasn't he, that police officers who were supposed to turn on their body-worn video had not, in terms of assessing their credibility?
I don't know if he took that into account.
You're entitled to take that into account. You are, aren't you?
Yes,
when
I
making
am.
an assessment. And Judge Borchers was entitled to take that into account.
But that is not in his summation, that he took that into account.
What Judge Borchers didn't know is that Constable Rolfe at that time had a history of not turning on his body-worn video when he was supposed to. Is that something that you took into account when you were making an assessment?
No, I did not.
How long are we going to speculate? What it didn't have, what it shouldn't
I
have?
think the
It's not
question's been answered.
speculation, it was a direct question and answer in relation to what was being taken into account.
In relation to an assessment of whether this matter should have been sent to the DPP for an independent assessment of whether perjury charges should be laid, did police give any consideration to whether or not the two officers, Zendelli or Rolfe, had any history of excessive force?
I can't tell you because I was not involved in that process.
Do you know whether or not in that process any consideration was given to whether either officer had previously been investigated for not telling the truth?
I can't tell you I wasn't involved in that process.
Do you think those matters are things that should be taken into account in assessing whether or not the investigation should go further?
Yes, it's all part of considerations of the background of the member, and everything should be taken into account.
It was put to you by Mr. O'Brien that in December 2019, when Superintendent Bryson was reviewing this incident, it should have been sent to the DPP as an objective oversight at that time. What was your answer to him then? Do you agree with that?
Yeah, I agree that it should have.
Is it the case that Superintendent Richard Bryson had refused to sign off on a charge for Constable Rolfe in November 2019 when he was charged with murder?
I do not know.
If that was the case, do you accept then that Superintendent Bryson might not be seen to be objective when asked to review the perjury charge a month later?
I don't know if you could say that because, like I said, Superintendent Bryson is a qualified lawyer. He's been in charge of prosecutions for a number of years. He's dealt with the Director of Public Prosecutions for a considerable time. I think he has the skills and experience to make an assessment.
Do you agree that the police oversight mechanisms have to not only be fair and objective, but also be perceived to be fair and objective?
Yes, I agree with that.
Do you really think if there's an officer who is involved or is asked to make a decision in relation to the charging of Constable Rolfe for the most serious crime on the criminal calendar a month earlier, he should really be the one determining whether or not a previous and refuses to charge, should be the one to make a decision about a perjury charge a month later? Do you not have a problem with that?
Well, like I said, I do have a problem, and myself, I would have referred it to DPP for an opinion.
I want to go back to the police response in the period between the Ryder incident and Kumanjayi's passing. Have you read the statement of Virginia Reid in this Coronial?
No, I haven't.
It appears at 7-115. Do you know what position Superintendent Reid held in the police force as at June 2019?
No, I do not.
I'm just going to turn to her statement for a moment and let you know. Superintendent Reid had oversight of various complaints against police involving Constable Roll. She has indicated in her statement that she was working with Professional Standards Command. She was at the relevant time the Divisional Superintendent for the Ethics and Integrity Division, having oversight of investigations into complaints against police investigations. Around June 2019, so about 4 months before Kumanjayi was killed, she indicates in paragraph 10, she spoke to Commander Curry and Superintendent Vickery during a command management team meeting. She advised them that she was reviewing a number of complaints referred to her from the Ombudsman Office, where Naja had raised concerns with the complaint outcomes and that it was likely they would be recategorised and further investigated. Do you follow so far?
Yes.
She said, I further conveyed that I was concerned about Constable Roll's non-adherence to the body-worn video policy and that this was the third occasion that I had become aware of people fleeing from him and injuries occurring when apprehended.
Yes, that's correct.
Do you know what response Superintendent Vickery gave when she was interviewed about this?
No, I do not.
In February 2020, in her interview for the benefit of the court, 7-133 at page 22, Superintendent Morgan said, it's apparent Rolf had a number of complaints, however, he was not removed from the IRT. And Vickery says, yes, so I guess we temper that with common sense. Because as I said, you know, at one point, every time we did an arrest job, members were getting complaints. So I guess we would look at that. If there was a serious complaint about an assault or something of a really serious nature, then we would obviously look at standing someone down. But for these lower level assault complaints, use of force type ones, it's not something that would have been deemed to be necessary to do that. And in fact, her evidence is that there was nothing of substance done to advise Constable Rolf in relation to his behaviours between June, when it was raised by Superintendent Reid, and November 2019, when Kumanjayi passed away. That was a dereliction of her duty, wasn't it?
Yes, and what you're saying it is, yes.
Superintendent Nobbs gave evidence that there were a range of options available in those circumstances. This is transcript 3072. He said a multitude of things ranging from welfare intervention for Constable Rolf, remedial support, placement in an administrative position while investigated, a first-person management plan, all sorts of things short of more significant oversight. That I withdraw that. All sorts of things that would have related to advice, support, oversight, review, that were not done by police during that 4-month period. That is a significant failing, isn't it?
Yes, I believe so.
Are you confident that with the reforms that have been implemented by Northern Territory Police after Kumanjayi's passing, the same situation wouldn't happen?
No, I'm not confident with what we put in place at the moment, but with the things that we're putting in place to complement it, I fully have confidence that we will have mechanisms in place to ensure, well, not ensure, you can never ensure, to mitigate any such occurrence reoccurring.
What's the time frame for those reforms being implemented?
It's varying. It's stuff that's already been implemented, being implemented now. Things like the Galliot review, especially when it comes to legislative reform, which is not a short-term turnaround. So those longer terms, such as the complaint and discipline system, as in how we manage that, is longer term, but that doesn't mean we don't have systems in place already through our SME initiative at the college, the mechanisms we have placed with the Ombudsman's Office in relation to flagging of matters, as well as timelines that are flagged. We have reduced the chance for things to slip through the gaps where we can identify at an earlier stage to identify if there's an issue with a member that needs to be addressed, which is why we're also really pushing ahead from a early intervention system perspective so that we have that mechanism in place to give us those indicators.
Do you agree? You heard from Ms Osmond's concerns from police about the way in which the complaints system has worked previously in terms of inconsistencies.
Yes.
It's important for police to have confidence in a fair and objective complaint system.
Yep, it's important for the community and the police to have that confidence.
And civilians, particularly Aboriginal persons who've made complaints previously that might not have gone anywhere, need to have some confidence, don't they, that the police will take complaints seriously and follow them up in a timely way.
Yes, no, I fully agree, because to have that trust and to ensure that people are being heard and that they believe that they have a proper system in place, you have to engender and build that trust and have that trust.
Thank you. Nothing further.
Just got the one question, Your Honour. I'm conscious of time. Assistant Commissioner, Council Assisting has just pointed out to you an aspect of unsatisfactory discharge of supervisory responsibilities. And then she followed up with asking you about whether that would be likely to happen again today. What has been done to deal with supervisors who are not as attentive as they ought to be in relation to their supervision?
So, excuse me, so those who aren't attentive and being identified is that we take action in relation to those supervisors from remedial advice up to part 4 action, but also as a development opportunity for them, we have also implemented the Sergeant Supervision Development course. We've also commissioned the Australian Institute of Police Management, where we also have a future leaders development course, which they run, which is from the technical skills of dealing in complex environments, having those difficult conversations. So more from a leadership perspective. So we have a 5-day workshop with that, which is also followed up with those participants. There are further follow-ups with the APM where they do have face-to-face follow-ups of how they're going, how they're applying it in the workplace. So we've run one of them. We've got another one due to start just in a couple of months, but we're going to roll them out across all the supervisor rank as well. We have the subject matter expert reviewing the use of force incidents, where the assessment by a supervisor is one of the key components of that assessment. And if they're not meeting the standards, it gets referred to the Professional Standards Command to either go out, if it's only a real minor matter, to go back to the command to deal with from a managerial perspective, or if it's misconduct, then from a disciplinary perspective. So there are a range of things that are being put in place, or have been put in place.
And on occasions when supervisors have not supervised adequately, has disciplinary action already been taken?
Yes, there's been a number of occasions.
Thank you.
Yes, thank you for coming back over a number of days to complete your evidence. That's appreciated, and we can adjourn till...
Before you rise, just a formality, I'll let Council Assistant know that I formally need to withdraw for the balance of this witness side in soon in the next 2 days.
Certainly.
All stand for 9 o'clock as adjourned.
Okay.